Oh, I should fix my light. What y'all doing in here? Yeah, the latest I've been seeing. Oh, my audio. So Doug Weinstein posted a second ago. He said, let's see. I've been working on the mistrial video. It's a little, I guess we got 9 minutes. They're saying 1 o'clock. I don't know if that's accurate because we'll see. But they've been saying 1 o'clock, and I made a video that's a little less than 10 minutes, so maybe I can play it. But let's see. Doug Weinstein just said, our client, Diamante Kendrick, has been wrongly accused and incarcerated since May 2022. We continue to fight for his freedom so that he can go home to his family and support system that all love him very much. He appreciates all the love and support from the public, whose words and deeds have helped sustain him during these many long months. That may sound like a rejection. Oh, okay. That may sound like a rejection, but I don't know. I mean, what do y'all think? They're also, Duggar Daily sounds like Yak rejected his plea, feed the guys. Of course, we know Jay Apt. I can't believe I'm not following him. He says free Yak Gotti. So, you know, we're still waiting, but they're talking about soon. I mean, it's not officially confirmed, but there are some words about other people, accepting. So it seems like this update will include some pleas, maybe not everybody. We'll see. It's all speculation. I don't be liking to do that. So we wait. Yeah, T. El Godi says supposedly Harvey's client took a plea 20-7. I saw people saying that. I saw people saying that. But until I see it and hear it, it's all, there's a bunch of people. There's people saying accepted, people saying it's not. We don't, I definitely have seen some people, some tweets. There is a rumor that Nichols accepted a 20-7, meaning 20 years, 7 in jail. The rest would be on probation. So he would spend 7 years incarcerated, and then 13 would be probation. I have it up. It's just not, live yet. So we're waiting. I had it up. I just know that they had the seal, but we're still waiting, y'all. We will see. Whose YouTube y'all been in on more than trying to get a bunch of non-confirmed tea? Some people, saying that they had direct conversations for sure. A seal is progress. A seal is definitely progress. For sure. I was I want to play it, but we got 6 minutes. We'll see. Here's what I've been working on all morning. Hold on.
Mr. Steele, what's your motion, sir?
So yes, I have a serious motion for a mistrial because it's intentional misconduct.
I will be moving for mistrial, which I presume will not be granted, but I'll protect the record. Your Honor, I tried to preempt it at the bench. It's exactly what I asked. I'm moving for a mistrial, and I did it at the proper moment.
All right. This case should be dismissed. This is outrageous.
You'd have to be a deceased person not to realize that the indictment is charging Jeffrey Williams in it. And the state just goes on like this is no big deal. Those are all my objections. I'm moving for a mistrial. I have no idea why this gentleman got to say Amina Diak works on the legitimate side.
Why in the world would any prosecutor, anywhere in this nation at any time ask a witness whether Jeffrey Williams was there? Nobody would say he was there. Nobody asked him to come. All it does is plants improperly in the mind of the jury. Jeffrey Williams was not bold like a lion, like Mr. Copeland, and go face the police that night. I'm moving for a... Sorry. I have a motion that I need to make outside the presence of Mr. Copeland. To me, that never...
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question. Whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. Why,
sir? I'm going to hold you in contempt if you don't tell me who the. Tell me who this
I
information
don't
was
want to
coming
be
from.
held in contempt.
Well,
I'm not
then
answering that question.
you got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes.
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial. I am moving for a mistrial. I have not waived anything. I just found out about this information.
You want the Harvey? Okay. All right. Okay. Mr.
I'm adopting all of the statements.
All right.
Good afternoon, Your Honor. Carlton Matthews here on behalf of Mr. Quamarvious Huey.
Okay.
We are also adopting all the arguments.
This is just a compilation I've been working on this morning. It's a mistrial compilation.
My attention, Mr. Weinstein, you filed a motion to recuse me. For the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay?
Every time Mr. Copeland comes in the courtroom or out of the courtroom, he's escorted by a DA's office investigator. You see that? You're not just sitting there in a cloud. You see exactly what's going on. You hear the prosecutor tell you, we were in a room with Mr. Copeland and he said these things. Why?
Okay.
Why do I have to bring up? You should be bringing up. This is crazy. This is like communist Russia. Mr. Williams is having the worst trial.
With all due respect, I want to renew my motion for mistrial.
I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning.
According to my notes, that was not supposed to be played in front of the jury. And at this point, I am moving for a mistrial on behalf of Mr. Stillwell.
So I am moving for a mistrial. I'm not moving off my mistrial. I'm just anticipating. No one wants a mistrial. I didn't want a mistrial, but why say that to a witness?
I adopt everything that my motion is the same. I adopt everything that Mr. Attorney Steele said.
All right, Mr. Sharp.
Your Honor, what just happened was completely dishonest, disingenuous, misleading, and gross. But I'm going to move for a mistrial. I think it was completely intentional. Obviously, it was calculated. Obviously, when I asked for clarification, I would think anyone seeking the truth would gladly clarify. I'm seeking the truth. I would gladly clarify. No, it's sheepish grin and then.
All right, I understand your objection.
Your Honor, may it please court, on behalf of Mr. Stillwell, we are moving for a mistrial at this time. Your Honor, at this time, I'm going to move for a mistrial on behalf of Mr. Stillwell.
Your Honor, this one
I have to still up on the other side, guy. I'm not going to
cannot be fixed.
I got it up.
404A, Your Honor.
I would just ask for the mistrial. I believe it will be denied, and that I could preserve it with a curative instruction. Yes.
Okay.
My motion is a motion for a mistrial. Based on the actions of the prosecutor. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it, and based on that, I would move for a mistrial.
All right, well, I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms. Love.
We feel in a position that we are forced to ask for a mistrial. We really don't want a mistrial. But if Mr. Mitchell is not testifying, then we feel we have no option but to ask for a mistrial.
Your Honor, we're making a motion for a mistrial on behalf of Mr. Nichols, and you cannot unring that bell. We would ask for a mistrial.
Your Honor, Carlton Matthews for Mr. Quamarvious Huey. We join in that motion for mistrial. So, Your Honor, we are joining in that motion.
First things first,
We live. I got you.
Miss Sylvia and Mr. Byron, if you all could both please come up to the podium. Yes, please. Thank you.
Can y'all hear? What's happening?
All right, so for both of you, I am sorry to have to say this, but I am going to be entering in order modifying each of your Rule 22s. It has come to my attention and I have confirmed that each of you has been recording in the courtroom while I have not been on the bench, and that is a clear violation of Rule 22. And so you may record today's proceedings, but after today, if you want to record, you're going to have to do it from the media room. You may be in here in the courtroom as a spectator without any recording equipment, or you may be in the media room to record, but no more with your equipment in the courtroom because y'all have both recorded things that you're not supposed to be recording based on Rule 22. So I'll enter those orders today. Thank you. All right. It is my understanding that we have a plea to be tendered for Mr. Nichols. Is that right?
A plea?
All right.
Your Honor, may we approach?
You may.
We getting a seal already? Yeah, that was Dennis Byron and then infamous Sylvia. The seal already. They are both media. They've been obviously recording this whole time. They've been media. They've been, yeah. His channel, Byron's channel is Hip Hop Inquirer, but also I think it's just Dennis Byron. Yeah, this is live. We are live right now. This is happening right now. First business of the day is they can't bring their recording equipment into the courtroom anymore. Sylvia and Dennis Byron. Wow. And we know she said a plea, so I don't know if it's a single plea, but definitely Nichols is up first. Sorry, y'all. I had a meeting scheduled at the same time. I'm like, I can't miss right now. I can't miss. Okay. So it sounds like the rumors about the Nichols ones is probably going to be true today, right? Like that 20-7 is probably accurate. I know it came from Shimel Drink's aunt, who I think was on Fani, who was on Sylvia's stream, I believe. I didn't get to watch it, but that's what the DMs have been saying. Also, I had a super chat, so let me, Big Tit, Fani will never let Nuts murder go, is what Big Tit is saying. Are you a Atlanta local? Out of curiosity. Well, y'all, bump that meeting. Listen, my husband is doing it, but I was like, let me just say two things. I want to pull up the right one. Somebody asked for, okay, so somebody asked for, I read, again, I don't know if it's true, but I read that Nichols murder charge, which was the Shimel Drinks one. I read that got dismissed. But let's see if we can pull them up exactly. So Quamarvious Nichols, count 1, which was the RICO, obviously. Count 49, which was the murder. That was for Shimel Drinks. Where did he go? Number 50 and 51 is for participation in criminal street gang. 51 is participation in criminal street gang activity. 53, 54. So 53 is possession of firearm by convicted felon, previously convicted of felony involving use of a firearm. So it's a firearm charge. And then 54 was possession of firearm during commission of a felony. And then the last one he got was possession of firearm by convicted felon, previously convicted. So he got 2 of those possession ones. So yeah, those are his charges. And it sounds like they're dropping the murder charge. And instead, basically, he's pleading out to these possession charges of firearm. Yes. Oh, am I not live? Oh, shoot.
Mr. Garland, who's going to...
Let me rewind just so, okay. Thank you. Kaz says, check the mod chat, please. Okay, give me a second. I need to check it right now.
And Mr. Harvey, Ms. Westmoreland, and Mr. Garland, who's going to be taking the lead going through the plea? Okay. All right, Mr. Harvey, do either you or you, Ms. Hilton, need this plea of guilty and waiver of rights form back?
Thank you.
All right, Mr. Nichols and Mr. Harvey, whenever y'all are ready, you can come on up to the podium.
Mr. Harvey said he's signing the indictment.
Okay. Whenever y'all are ready.
Your Honor, I'd like my client to be present for this. He's a member of the public, and I would like him to observe this, and he has a right to be here.
Okay.
Thank you.
That's sounding like...
Can we get Mr. Kendrick out, please?
Sounded like Kendrick is... Sounded like it's a no for Kendrick. Let me fast forward a little bit. We're a little behind.
Yeah, can I approach?
Okay, another approach. I'm going to fast forward again because I got a little behind. Thank you for that flag. Okay, so Weinstein has asked for his client to be present. Let's make sure we hit play so we're not behind again. I'm assuming maybe if there wasn't a deal with Yak, that they defendants who didn't take a deal, I'm assuming maybe they put him in the back. And so that's why he's asking for...
Okay. We're going to recess for just a minute, and I am sorry about that, but I'm going to have to ask everybody to step out for just a minute, and then we'll let y'all back in, okay?
Take it! Yeah! There we go, y'all. We back. We back. We back. I wonder why. I wonder what conversation has to be had again, right? Like, I wonder why they had to break again. Okay, let me try to do this for the mod in the chat while we are breaking. I don't know, guys. I don't know. Why would they need to break again? It's numbers are in, agreements are in or not. It's interesting. I'm anxious to know, is it just Nichols at this point? Because she said we have a plea and not like we have pleas. Maybe I'm reading too much into it, but you know what I'm saying? Like, as of right now, Nichols. We know for sure Nichols. And I mean, which is not surprising given the fact that this whole time Bruce Harvey has been asking to be severed, like for him to be severed. And again, at the end of the day, it's the client's choice, right? So Harvey asking to be severed doesn't necessarily mean like for sure. But it does seem less surprising that Nichols would plead out. It also, apparently, he has other charges going on in another county. So, you know. Okay, Crystal Bettina is saying she thinks it's just Nichols. Appreciate you. Subscribe to our channel, support the page. Appreciate you. What you've missed, Beetlejuice Q. You've missed that the first business of the day was the judge telling infamous Sylvia and Dennis Byron, who are members of the press who've been, recording and vlogging and, really documenting this case from the beginning. The judge said that she is modifying their Rule 22s because you are not supposed to be filming in the courtroom at certain times. And she says she has saw and verified herself that they were. And for that reason, she is modifying their Rule 22s. Their equipment cannot come into the courtroom anymore. They will be back in that media. Their equipment will be in the media room. They will be in the front, which is interesting. And then Nichols. It's Nichols. The jury is not there. I can confirm that 100%. Jury is not there. Well, and I should say not in the courtroom. I'd imagine they're probably not there today, but maybe I could be wrong. They're for sure not in the courtroom. They wouldn't witness this. I guess Doug wants him in there so he can witness Nichols signing the acknowledgments and how that implicates his client. That could be true because the thing that we know about pleas, also Dennis Byron just tweeted WTF. So, yeah, if no one else is in the courtroom and you can take that context from what Doug said, then again, maybe he's the only one for the day. Maybe he's the only one. Maybe we keep going. Big news of the day. Love Leather said, I'm headed to the courtroom right now to be nosy. I will tell you, you probably will not get into the actual courtroom. They have the last row, which is the row for spectators, public, is a row that seats about 8 people. And unless you are one of the first, especially today, they ain't gonna let you in. You're gonna be in the overflow. But I'm not telling you not to go. I'm just letting you know. Yeah, man. Oh, Blazin' Marley says the state's mad at Sylvia because of her show last night. Because of her show with Nichols' aunt, I'm assuming is what you're referring to, right? Which is where that information came out. Got it. There it is, right? Big question is, will he testify or admit YSL is a gang? The thing that crosses my mind for that, y'all know I'm not a lawyer, but he's been sitting in there as a defendant. So I don't know the kind of instruction. I don't know the instruction that is given to the jurors as to how to take his the context of what he would say. If this is the case, I'm not sure. It's feeling like that would be really sticky and weird to happen, because think about it. The jurors have now seen him as a defendant this whole time. And so if he's called all of a sudden as a witness and there's no clear explanation, I think in general, the way the judge is going to have to work through what is told to the jurors after this point is going to be interesting. They're going to have to work through the limiting instruction. Y'all know we love some curative limiting instructions around here. What do you say? Girl, what do you say to the jurors who have now gone through so much, and now you have to tell them, hey, one of the defendants is gone now, so don't worry about that. Just, what's the Men in Black? They gonna Men in Black you. Forget about that. What do you say? That's gonna be really interesting. And to the point you're making, if there is, I don't know if it's possible. I don't know if it's a thing. But if he has factual acknowledgments that would require him to testify to in this trial, that's ugly. That's ugly. I don't know. I think the jurors probably won't be expected to come to court for a couple days, because I imagine they're going to have to talk about what is told to the jury. I don't know what's appropriate to tell them, and I'm not sure what's not appropriate to tell them. So the fact that everybody would have to collaborate and come up with what they do tell now, I don't know. Brianna, we had action. We had action for a second, and then it went away. The jurors are not sequestered. The jurors go home every day to their house. They are not sequestered. Sequestered would mean putting them in a hotel room and like keeping them from, the general public and all of that kind of stuff. These people go home every day. They come in and they go home every day. Cass, let me do what I told you I was going to do. What did we confirm? We've only confirmed that he took a plea. I've heard and seen it's 20 years to do 7 in jail. The rest would be 13 would be probation. That's what I've seen. Obviously, we haven't heard that be said out loud yet. That is just what is rumored. But it seems like we're very close for those details to come out. This jury going to get rich after this. Jurors, if you're at home, if you happen to be at home today because you're not in the courtroom and you're wondering what the heck is going on in the trial you've been on for a year, and you want to at some point come on I'm Not a Lawyer But and talk to the non-lawyer about it, DM me, okay? I won't tell. We can go live when you're ready to go live. When the trial is over, we can talk, okay? I'm not a lawyer, but DM me. I'm here for you. Listen. Oh, am I late again, y'all? No. Okay. Girl, you scared me. You said it's on, and I'm like, I try to make sure it's live. Right? We got to clip that and post it. Come see me, jurors. Come see me. I want to hear all about it. Yeah, I can't even imagine how much this would cost for these attorneys. Like how much it costs to have an attorney fight your case for this long. I cannot imagine how much money that is. Mel, will the judge rule in her motion for mistrial after the plea deal? Here's what's interesting. One of the first people to request a plea deal was Nicole Westmoreland on behalf of Quamarvious Nichols. Marquavious Huey, Quamarvious Nichols. Sorry, I get it's the Quay and the Ma. I'd be like, which one? But anyway, so if she's taken a plea, her now motion for a mistrial would be done because they're taking a plea. It's worth noting that Marquavious Huey's attorney also, because he was the other Quay, also had a motion for mistrial. So if there was a motion for mistrial from him as well, if they take a plea, I would imagine the motions for mistrials are done now. If Huey does not take a plea, I would imagine that that motion still has to be addressed. I'm not a lawyer, but that's just the way I think through it. Hopefully that makes sense. If Harvey's gone, what happens to the Harvey rule? Good point. Good point. Listen, are we all Quays? Are we all Quay? Oh. The Harvey rule was after Bruce Harvey, and it was specific to this trial. But it's something that Glanville named early on because Bruce Harvey would always ask, because there's so many, he would be like, instead of us all having to raise our hand to say, like, I join in, I object, I'm motion, he wanted it to just be applied across the board to all of the defendants. And so they named it the Harvey rule, which is just, okay, this is a motion, but it's applying to everybody, or this is a that, and it's an objection and it applies to everybody. So that was the Harvey rule. But again, it was after Bruce Harvey, and now that his client is officially accepting a plea, he's gone. So they're just saying, can it still be called the Harvey rule when Bruce Harvey's not here? I don't know no Quays. Rose says I'm not Quay, but I do know. I don't know any Quays. Y'all know Quays? If you know a Quay, put it in the chat because I want to see how many of y'all know Quays. Listen, Brianna is here for the shenanigans. I am too. I am so curious as to how, even, y'all know I'm not a lawyer, but I get really nerdy about this kind of stuff. So I do some of the questions y'all are asking. I have the same questions. Like, how does this work? Some people can take a plea. Everybody doesn't have to. What do you tell the jurors? How do they come back from this? I have so many questions about where you go from here. So even on a nerdy front, I'm just very curious. Okay. We got some answers for the Quays. Blue says, I know a Quay. Britt Iraq says, I know a few actually. Ingrid has 2. Quamarvious. Gaston said, Sweet July says 1. Deborah says not a single one. Okay, me and you. Counselor Kia says no Quays. Okay, the no Quays, it's 3 of us. Sylvia says, I don't know nary a Quay. We 4 of us. Kayla knows a Quay. Dewana says her daughter is a Quay. What's her name? If you want to tell it, you ain't got to tell it. That's your business. Latoya knows multiple row. And I think the Quay I know is free. Amen. Free Quay. All Quays I know are bad as hell. Not bad as hell. Creative Gariel. I know a Quay. I don't know a Quay. Okay, so we have 5. Big Lou says I know a few Quays. How y'all know so many Quays? Kayla says I know 4. Me, but I'm from Atlanta. You know the Quays in this case. Court Nicole, you know the Quays in this case, or you just know some Quays. I know a Quay. I actually do. I'm so nerdy. Good. My god sister's a Quay. All right. Apparently, Quay is. You know 4 Quays. Okay. Apparently, y'all know. 41 Vixen said, hey, Mel and all. Mel, I wish you would stream live more often. I love to absorb your knowledge and breakdowns. Thank you. I do try to. It's less knowledge in the Patreon. We just be hanging out with me acting crazy, running around, jumping up and down. But thank you. I do appreciate it. I do want to stream more often. It's just my schedule, child. But I do want to work out, like, how to pull it together. So I can get on here a little more often. Oh, are we live? We got a little movement. Hi, Mel. The last witness and probably will take the stand again. I felt so bad for him because he was shook with love. Being present during his testimony was a reminder for him of what happened to MT. I do imagine they would pick back up because if you recall, we were in the middle of the state discussing Rodalius Ryan's murder conviction. That was like the part of the trial we were in. So if we pick it back up, I imagine Wooney Lee, that was the witness, he would be called back to testify. I imagine that's where after we get through this, we just pick up. Spark White says, as a juror, I would take the series and not look at the news. You know what? To give the benefit of the doubt. Oh, let me shut up. Yes, I have been hearing that, Monique. 20 but 7 to serve. Yep. That's what's being reported. Okay. I was saying something, I forgot. The movement got me excited. Small Time is saying, question, can the defendants that take a plea deal turn against, and by turn against, I think you mean probably have factual acknowledgments and have to get on the witness stand, maybe, turn against the defendants that don't for a better deal? I would imagine the factual, this is something we've been discussing, right? It's not clear. That's one of the questions I have is, let's call it Quamarvious Nichols, obviously takes I keep getting nervous, y'all, takes a plea. With his plea, are there factual acknowledgments that would require him to get on the stand? And how is that explained to the defendants? That feels very tricky, prejudicial. Like, as a juror, imagine you're like, oh, this whole time he has been a defendant, and all of a sudden I see him on the witness stand and he's admitting, yes, this is a gang. Yes, we did these things. Yeah, you know what I'm saying? Like, that would be wildly prejudicial, it seems. I'm not a lawyer. That's how it seems. So I imagine that there's going to be a ton of discussion about what happens, but I don't want to speculate. I don't know the answer to that. But as all the plea deals have been having factual acknowledgments, I think it would be wild to assume that that's not a part of his deal. But we've also seen, right? We know Ashley Merchant's client, his plea was very interesting, right? His plea didn't even call it factual acknowledgments, and it never really said, I don't believe it said YSL is a gang. So, and Quamarvious Nichols, his attorney is Bruce Harvey, and he ain't brand new to this. Harvey is old school and he's been doing this for a while. So maybe he also got, his client and Nicole Westmoreland is also not a gang. So maybe, if he has a great attorney like Ashley Merchant got for her client, his deal was really good. So maybe he gets a good, I don't know. It's also a different setting. This is in the middle of the trial. There's a lot of, trials and law is all gray area. As much as we want it to be black and white, it's black and white until you can find another case to support what you're saying. So, Carly, I think it is Carly Phillips. Oh wait, your question is, will you cover Dirk's as well? Dirk's trial is the United States of America versus. Anytime it's United States of America versus, that means it's a federal case, okay? If it's a state case, meaning California versus, then it would be, we could potentially stream and all of that stuff. When it is federal, cameras are not allowed in the federal courthouses. So as much as I would love, and it's going to be here, so maybe I'll be able to go, but it wouldn't be like a video-based recap. It wouldn't be, I would have to figure out a way to do it in another way, because USA versus means Fed. What else we got? I know that's been Leah Ray. I saw it going crazy too. That video of Harvey in another courtroom. I don't know the full context. I haven't looked into it yet, but I saw him getting turned up, which is, what people say about him. They say he's not a game. So, I think I wouldn't be surprised if from this there are some requests from bail. I wouldn't be surprised. I wouldn't be surprised. Oh, 41 Vixen. Shout out to the new member. Thank you for joining. We love leather still talking about the Quays. We got Quays all over Atlanta. I don't think I knew any. Oh, for sure. This is history making for already. Sandra, I keep getting distracted, girl. Let me do what I'm supposed to be doing. Oh my gosh, I'm about to text Maurice. You keep moving the camera and it's getting us excited. Stay still. See?
All right, apologize for the interruption. Thanks for y'all's patience. Some of the co-defendants in the ongoing trial wanted to be out here, so they are out here now. And Mr. Harvey, are we ready with Mr. Nichols?
Yes.
All right.
Do you want him at the podium or do you want him here seated?
I think at the podium, please. Thank you.
I think that's on. Thank you.
Now let's have him at the podium because he's going to have to take an active part in this entry. All right.
Okay, sure.
Sergeant, can you swear him in, please?
Raise your right hand. So I firm testimony you give the truth, the whole truth, and nothing but the truth.
Yes.
All right. State, spell your first last name for the court, so now to the mic, please, sir.
Quamarvious Nichols, Quamarvious, last name Nichols, Nichols.
Did you
All
get
right.
that, Jack? Okay. Do you want to do it again? All right. Slow down. Your name. Spell it for this young lady right here.
Okay, my name is Quamarvious Nichols, first name Quamarvious, my last name Nichols, Nichols.
And Mr. Nichols, are you the same person referred to as Quamarvious Nichols on indictment 22 SC 183572?
Yes,
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
no,
Have you had the opportunity to sign this indictment with your attorney, Mr. Bruce Harvey?
yes,
How old are you?
29.
And how far did you go in school?
I got my GED.
I did not hear you.
I got my GED.
Are you able to read, write, and understand the English language?
Yes,
Do you understand that in this indictment, you were initially charged with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carries a sentence of 5 to 20 years. You were also charged with count 49 in this indictment, which is murder, which carries a sentence of life. You were charged with 2 counts of participation in criminal street gang activity, which was counts 50 and 51, which each carried a sentence of 5 to 20 years. You were initially charged with counts 53 and 65, possession of a firearm by a convicted felon under Code Section 16-11-133, which each carry a sentence of 15 years consecutive to count 1. And then you were also charged with count 54, which is possession of a firearm during the commission of a felony, which carried a sentence of 5 years consecutive to count 1. Do you understand that that is what you were initially charged with?
yes,
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
yes,
Have you had an opportunity to go over and review the waiver of rights form with your attorney?
yes,
And I'm going to hand this to your attorney. Did you sign this along with your attorney?
yes.
Have you had enough time to speak with your attorney, Mr. Bruce Harvey, about all the facts and circumstances known to you regarding the charge in this indictment?
Yes.
Do you need any more time to discuss this man with your attorney?
No.
Are you satisfied with his counsel and representation?
Yes.
And I'd include in there the counsel and representation by Ms. Westmoreland and Mr. Garland as well. You had a team of attorneys.
That's correct.
All right.
And they are all attorneys of record and have participated in this particular proceeding and negotiations leading up to this proceeding.
Thank you.
Do you waive formal reading of the indictment?
Yes.
Yes.
Do you waive any and all defects with respect to the indictment?
Yes.
And to your knowledge, have you been arrested on all the charges in this indictment?
Yes.
And Mr. Harvey, the state is unaware of any outstanding warrants related to these charges. Do you know of any outstanding warrants that are related to these charges?
Not related to those charges.
Have you been advised of the minimum and maximum sentence for each charge that you are pleading to?
Yes.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court as to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, a sentence of 20 years to serve 7 years in custody, balance on probation.
Yes.
Do you understand as a part of the negotiated agreement, the state will null, pros, or dismiss count 49, which is the murder count, count 50, 51, which are the gang activity counts, count 53, possession of a firearm by a convicted felon, count 54, possession of a firearm during the commission of a felony, and count 65, possession of a firearm by a convicted felon. Do you understand that is the negotiated agreement?
Yes.
Do you understand that the court does not have to accept that recommendation?
Yes.
And the court can sentence you to the maximum on each charge and can run those charges consecutively or one after the other?
Yes.
Well, there's only one charge that a guilty plea is being entered into, so
Under my breath to that.
there's no other sentence to run anything consecutively with regard to this plea. You understand that?
Yes.
Okay.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes.
Do you understand you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Partisan Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? After each right, I'll ask you to say yes or no if you understand. The right to a trial by jury.
Yes.
The right to remain silent and not incriminate yourself.
Yes.
The right to confront witnesses against you.
Yes.
The right to assist with counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case.
Yes.
The right to the presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence.
Yes.
The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have the charges against you proved beyond a reasonable doubt.
Yes.
The right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
With respect to indictment 22 SC 183572, how do you plead to count 1, conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
And that can challenge anything about the constitutionality of the plea. It's not limited to voluntariness, understand?
Yes.
And Your Honor, if this case were to
Hang on just a second. You also have, so 4 years for that to file a direct appeal. You have 30 days from the date of sentencing, which is going to be today. And you have until the end of this term of court to file a motion seeking to withdraw your guilty plea. That doesn't mean anything like that would be granted. You would have to establish facts that would warrant that. But that's just the time period is until the end of this term of court. Do you understand those as well?
Yes.
All right. Your Honor, if this case were to continue with trial, Your Honor, the state would expect, as to this defendant, the state would expect to show that what has already come into evidence that on July 3rd, 2017, as well as October 23rd, 2018, that this defendant is an associate of the enterprise of YSL, also known as Young Slime Life, and that he conspired to associate together with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. In furtherance of the conspiracy, this defendant engaged in the activities below. He engaged in activities that assisted with preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity to include murder, assault, and threats of violence. That this defendant preserved, protect, and enhance the reputation, power, and territory of the enterprise by the posting of messages, images, appearance in videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf, and to obtain money, weapons, and other property through acts of racketeering activity, including the unlawful sale and distribution of drugs. Your Honor, evidence has come in during this trial that on July 3rd, 2017, Mr. Nichols was located at 2612 Steele Avenue, which is in the Cleveland Avenue sector of the city. Your Honor, he was found inside of a vehicle. When that vehicle was searched, Your Honor, this was in October 2018, they found marijuana as well as sandwich baggies that would be used to package drugs. And there are also guns found inside of that vehicle. Also in July of 2017, this defendant was stopped during a traffic stop in the Cascade area, Your Honor. After being stopped, Your Honor, there was a consensual search of the vehicle that yielded powder MDMA, Xanax, as well as a loaded gun inside of that vehicle. Additionally, Your Honor, in July of 2019, Mr. Nichols was featured in a video with another YSL member, Shannon Stillwell, and Wooney Lee. In that video, it was entitled Slat Talk. And in that video, co-conspirator Shannon Stillwell, while performing, makes such quotes as, "Me and my slimes are above the law." We know from the evidence that slimes is one of the terminology used by members of YSL to refer to themselves or other members of this enterprise. And then last but certainly not least, Your Honor, that in March of 2022, Your Honor, Mr. Nichols was found in surveillance video at a gas station at Windsor, Street and Fulton Street here in Atlanta, Georgia. This was on March 14, 2022, during what the state would believe to show an onset of a gang war that really started in 2015 with the death of Donovan Thomas that carried on into 2022. In February of 2022, a rival gang member by the name of Rayshawn Bennett, also known as YFN Lucci, was stabbed at the Fulton County Jail in February of 2022. Information about that stabbing was made public at the early part of March 2022, around March 3rd of 2022. Once that information was released to the public, there was an onset of retaliatory activity that occurred between March 3rd, 2022 and March 16th of 2022. That includes a March 11th homicide of YSL associates Christian McMiller and Darius Ford. It also did include a retaliatory shooting of a YFN associate, and then ultimately it led to a murder of Shamel Drinks, who we believe is a YFN associate. This murder occurred again on March 14, 2022. Mr. Nichols is seen on surveillance video at that BP gas station, as I just referenced earlier. He was at the gas station with YSL co-conspirator Shannon Stillwell. Mr. Stillwell was driving an Audi vehicle. Mr. Nichols came to that gas station in a Ford Fusion vehicle. You see both of them on camera together. While they are at that gas station, Shamel Drinks approaches that gas station as well. I think unbeknownst to Mr. Drinks, Mr. Stillwell was still in his vehicle, which is the Audi. At some point in time, Mr. Nichols got into his vehicle, the Ford Fusion. Once Mr. Drinks finished his business or finished handling business at that gas station, we know that there is a phone call between occupants of the car that Mr. Stillwell was in and occupants of the car that Mr. Nichols was in. That communication was to the effect that we need to get on FaceTime. As soon as that conversation ensues, we see Mr. Drinks leave the gas station in his vehicle, and both the car that Mr. Stillwell is driving, as well as the car that Mr. Nichols is driving, both follow out of the gas station, following behind Mr. Drinks. Mr. Drinks proceeds down the street to the light at Windsor, which is right by I-20 in Windsor. Mr. Drinks is in the far left lane. The car involving with Mr. Stillwell pulls up to the middle lane, and Mr. Nichols' vehicle pulls up to the far right lane. This is all captured on surveillance video and surveillance camera. They are at the light for a moment. Then we see both this car with Mr. Stillwell as well as the car with Mr. Nichols drive through a red light, leaving the car with Mr. Drinks sitting at that light. About 30 minutes later, a Good Samaritan sees that car still sitting there, approaches the vehicle, and Mr. Drinks is now deceased inside of that vehicle. We had known through LPR readers that both Mr. Stillwell's vehicle and the car involving Mr. Nichols drive in the direction of 20 westbound and follow in tandem. 2 days later, when after the case is investigated and arrest warrants are taken out, on March 17th, 3 days later, Mr. Nichols is found with Mr. Stillwell at a Chick-fil-A gas station, Chick-fil-A restaurant. There is a chase, I won't call it a high-speed chase, but there is a chase through the city of East Point, and eventually Mr. Nichols as well as Mr. Stillwell are both apprehended after arrest warrants were ultimately taken out for the murder of Mr. Drinks, Your Honor. Given where we are in the case, Your Honor, we know that Mr. Nichols, we do not believe Mr. Nichols was in the vehicle in which the shooting occurred, but he was in this other vehicle. The state has made the decision to move forward with this recommendation for the RICO count, Your Honor, for count one.
Mr. Harvey, are y'all acknowledging a factual basis to the count one, the RICO count?
Okay, we are acknowledging a factual basis. There has already been evidence with regard to the July 3rd, 2017 drug event. the October 23rd, 2018 drug event. We categorically deny and contest any use of violence by Mr. Nichols. We don't agree to that underlying factual basis. We believe those two predicate acts that were committed by Mr. Nichols without any question are sufficient to meet the elements of the offense. The offense to which he's pleaded to, which is a RICO conspiracy.
You pay.
A RICO conspiracy requires proof that the defendant either conspire with another person to violate one of the substantive provisions of RICO, and that would be drug offenses, or personally endeavor, I believe that's what the language of the statute says, to violate one of the substantive provisions.
Well, that's what the language of the statute says, but
Yes.
he is indicted in this indictment with conspiring, not with endeavoring.
That's correct. So we're talking about a conspiracy. We acknowledge the two events that he participated in. We categorically deny any other allegations other than those two events that are sufficient for a factual basis. We categorically deny that we participated in any way in the unfortunate death of Mr. Drinks. We categorically deny any other charges to which we are, substantive charges to which we are not entering a plea, and that includes gang charges. This is a plea solely to a conspiracy to violate the RICO Act. So that, but yes, we acknowledge a factual basis to that extent, Your Honor.
Understood. All right, thank you.
Your Honor, we just have one additional thing to say.
Go ahead.
The factual basis regarding the nature of YSL is that the evidence has shown and will continue to show that Mr. Nichols conspired with others to participate in Young Slime Life through a pattern of racketeering activity, and multiple defendants and unindicted co-conspirators have committed overt acts to further this conspiracy, including drug sales, aggravated assault, and murder, also including social media posts asserting the violent nature of and asserted dominance of Young Slime Life, also known as YSL. And that concludes our factual basis.
And again, once again, we categorically deny those representations. And again, the only thing that is necessary to meet the factual evidence of a 1614-4C is proof that the defendant conspire with another person to violate one of the substantive provisions of RICO, and that is subsumed by the drug offenses that have already been proven in this case, and to which Mr. Nichols has previously pled.
All right, thank you. Understood.
And Your Honor, may I approach with the waiver of rights form?
Yes. All right, Mr. Harvey, have you reviewed with Mr. Nichols this plea of guilty and waiver of rights form, which the two of you have both signed?
I have, Judge, in each individual provision in that plea colloquy has been acknowledged and gone over personally with Mr. Nichols.
All right. And Mr. Nichols, have you had sufficient time to consider this guilty plea that has been negotiated between the state and your attorneys, and to discuss anything you wanted to about that with your attorneys?
Yes.
All right. And you understand, I hope, I'm going to ask you, that it is your decision ultimately, obviously with the advice of your attorneys, but it's ultimately up to you individually to decide whether you want to enter this guilty plea or not. Do you understand that?
Yes.
All right. And you do want to enter this guilty plea?
Yes.
All right. And Mr. Harvey, have you advised Mr. Nichols of the alternatives if he does not ultimately go through with this guilty plea and the potential benefits and drawbacks of all of the other options?
Yes,
All right.
very thoroughly, Judge.
All right. All right, Mr. Harvey, is there anything that the defense wants to add to the record?
Judge, other than the statement with regard to the underlying factual basis, I would point out for the court that when Mr. Nichols filled out his form, it says 29 plus. He is a birthday boy in a couple of days and he will be 30. And at 30 years of age, he has a wife. He has got a 13-year-old daughter. He's got a 10-year-old daughter and an 8-year-old son. His wife and sister, I believe, are here in the courtroom to support him. He, Mr. Nichols, was born and raised in Atlanta. And, you know, we're at this point before I have even given my opening statement in this case.
Yes, sir.
I do want the court to know that Mr. Nichols' mother died in prison. His father was shot by the Atlanta police when he was 4 years old. And he was raised by friends and family in the Atlanta area. So he has come to this point in his life from a very humble beginning. And he has sought the support of friends in this courtroom and others in this courtroom.
Is he getting emotional?
He is an intelligent young man who I believe has a future. Every day we do a word of the day. We put a new word into a sentence. And I think this is in his best interest. I know that there is, and I know this plea is negotiated, but it's a long downside from 7 to 20. So the courts will have jurisdiction over him for a period of time. So I asked the court, given who this young man is, and given our categorical denial of some of the factual basis, to accept the plea and sentence Mr. Nichols accordingly.
Mr. Nichols, is there anything that you want to say?
No, ma'am.
All right. All right, I find there to be a factual basis for the guilty plea to the RICO count one of the indictment, that being a conspiracy to acquire control or interest in money and personal property through a pattern of racketeering activity. And that is the only count that guilty plea is being entered for. The remaining counts of this indictment as against Mr. Nichols are being null pros by the state as a part of this indictment. I find, having heard the evidence up to the point of trial right now, that there is evidence of at least one overt act in furtherance of the conspiracy. And that there is evidence that would fall within the required statute of limitations to establish this RICO conspiracy count. One of the things that we as judges are instructed by our Uniform Superior Court rules to do when we are considering whether to accept a guilty plea and whether to accept a negotiated sentence, and this is a negotiated sentence in this case, is to take into account whether giving leniency in sentencing is going to aid in ensuring promptness and certainty, or at least more promptness and more certainty with regard to corrective measures, whether the defendant, and in this case, the defendant has acknowledged guilt and is accepting responsibility for his guilt of the RICO count, and whether accepting the plea will aid in avoiding further delays, not just with regard to this case, but with regard to the entirety of our system here in Fulton County. And this plea does go towards doing all of those things. I am going to accept the plea as negotiated and sentence in accord with the negotiated recommendation. As I said before, find there to be a factual basis for count one of the plea. I find the plea to have been freely, knowingly, intelligently, and voluntarily entered into by Mr. Nichols with an understanding of the consequences of doing that. And the sentence on count one is the sentence that has been negotiated of 20 years to serve 7, with the balance of those years to be served on probation. And that, I don't know if there are any special conditions attached to this that y'all have talked about at all.
There are no negotiated special
Okay.
conditions in those, but there are none as far as I'm concerned.
All right. No. Okay. So with regard to the time that you are on probation, you need to stay out of all kinds of criminal trouble. Make this a birthday present to yourself and to your children and to your wife and family, that you will leave from here today and leave whatever you used to do behind you, and take the next few years. You know, you're going to have some years that are still to be served on this. You'll have credit for the time you've already served, but you're still going to be facing some incarceration time. But after that, you are going to be out, and you, I believe Mr. Harvey is correct, can be a productive member of society. And this is an opportunity for you to do that, and for you to put your past behind you, the bad parts of it, and continue and make your children proud of you, and set a good example for them, an example that I guess unfortunately you were not lucky enough to have throughout the entirety of your childhood with your parents. I'm sorry about that, but you can be the kind of parent that you ought to be to your children. So I am going to impose that sentence, and I am going to wish you luck and good fortune as you go forth from here. So I think that unless there's anything else from either party, that will conclude these proceedings, and y'all can go ahead and take him into custody. Thank you.
Thank you.
And Ms. Taylor will make this an exhibit to the plea. Thank you. All right, we are adjourned for the day. Oh, Nick, I think I handed you the wrong.
Oops. Wow. I'm sure people are like, girl. So I'm not even going to be able to be on here long. I got to go make a clip for the people. Let me just say what happened, though, so we're clear. Because she covered a lot. And I think what was really interesting is that Harvey made it plain. I told y'all right beforehand, if he's going to do it like Ashley Merchant. And I think that he was very smart. Nichols had a bunch of charges. This negotiation resulted in no pros, not being prosecuted for all but one charge, which is the RICO charge. Okay, so he basically said, I'm admitting guilt to this one, and I'm not admitting guilt to everything else. What Hilton did was go through, what they're saying happened in regards to the Shymel Drinks murder, but he didn't have to plead to that. He did not. And even with this RICO, what Harvey is saying is, in order to plead guilty to the RICO, we are saying that these two events have these. She gave the dates, and I pulled up the indictment. So on July 7th, let's just pull it up really quick. It's overt act number 67. Hold on. Oh my gosh, what a time. Okay, let me share this tab. Give me a second. If you care about this stuff. If you don't, I get, if you're like, girl, it's over. Okay, let me make it big. So what he was saying, what Harvey was basically saying is, we are saying, yes, number 67, overt act, which says that defendant Quamarvious Nichols, an associate of YSL, did unlawfully commit the felony offense of participation in criminal street gang, blah, blah, blah. He had possession of MDMA with intent to distribute. Okay. So he is saying on that day, yeah, he had that. And so he's also saying number, I think it's 77. Let me scroll down. Okay. He's saying the next one was October 23rd, 2018. And he's saying, yeah, for that one, defendant Quamarvious Nichols, an associate, okay, he had a possession of a firearm by a convicted felon, possession of MDA with intent to distribute, and possession of firearm. So his Harvey was saying, all we have to do is say that two of these things are true, and that is enough to substantiate RICO number, the first count RICO. So he's saying, yes, I'm admitting to guilt to these things, which is why I'm admitting to guilt to count one. But at that other stuff you're talking about, Harvey was very clear. We're not saying that that happened. Everything you're saying in regards to violence, we are saying no. And so he did not admit to murdering. Essentially, they did not admit to the facts that the state is saying they have. Here's the question I have, though. When it comes to murder, how do you, as the state, decide to null pros? How do you dismiss that charge? And this is why I'm talking about the other day when I was talking about justice for family. If you can just as easily dismiss that charge, why did you charge it in the first place? Do you know what happened? Do you actually know? Like, that is what feels so weird for me, is like, how does it go away so quick if you actually don't believe that it happened? You know what I'm saying? Like, who is this really about? Were you overreaching? You charge everybody because you don't know who it was. And so you make these families go through this. The people who love Shymel Drinks, who have gone through this, and then you call them to say, hey, we're going to dismiss it against him. Did you just tell? At some point, the state must have adamantly been on the phone with them, telling them, oh my gosh, we found him, we're going to prosecute him. And now here you are saying the opposite. Like, as a family member, I feel like I would be heartbroken, because do you know what happened or not? Don't play with people's lives and families like that. Anyway, Bruce Harvey was unequivocal in his response of, he is not admitting to that. He's only admitting to count one, the RICO. And so because of that and everything else getting dismissed, he is 20-1. He got sentenced 20 years, only has to serve 7. I said 20-1. Only has to serve 7, and they gave him time served. So he's been in there since May of 2022. So he is about 2.5 years. So if you take 7 years, you subtract 2.5, what are you at, 4.5? Yeah. So he has to spend 4.5 years in jail or prison. And you heard her say, are there any special conditions? Special conditions would be, he has to get on the stand and admit. He has to get on the stand and say, there are no special conditions. That means he will not be a witness. He does not have to be a witness for any of these cases. There are no special conditions. The only condition is he said guilty count 1, signing on the dotted line. I'll go serve my 7, which is really down to 4.5, and then I'll be on my way. So he does not have to testify. He does not have to, none of those things. It didn't even say, if you listen, he didn't even have to admit that if there's no special conditions, that means he didn't have to say YSL is a criminal street gang. He just said, I did these 2 counts. And I admit that they were a violation of the RICO. And for that, I'll take my 7. So I'm not a lawyer, but I would argue that was a good deal. I would argue Bruce Harvey and Nicole Westmoreland and Mr. Garland. Okay, I would imagine that was a deal that makes sense for him, a deal that makes sense, and he's the only one who took it. Hey, that's my opinion. I'm sure a real lawyer is probably itching to correct me, but I imagine that that's a good deal. That is something that makes sense. I hope, and I got emotional at the end too. That was so when Harvey got emotional, I said, "Oh my gosh," because, and I have said this before, the reality, like, these are people's real lives, both sides. The victims, Shymel Drinks was a real person who was killed, and his family has to deal with that loss. Like, those are real people. Quamarvious Nichols is a real person who has a wife and kids. Like, these are real lives. And so you can only hope and pray that what Whitaker said, that you take these moments and you really change and you really make the impact. You know what I'm saying? Like, you can only take that. And where that leaves the victims' families, I don't know, child. I don't know where you leave the victims' families. Because you told us that y'all was going to get who did it. You told us he was a part of it. You know? So, yeah. Hearing that about his parents, I think that's also that kind of context. What Harvey said, he did not give an opening statement. He waived his. He was going to give it at a later point. He waived his opening statement. So that was the first time we ever got that context about Quamarvious Nichols' life, right? We heard Jeffrey Williams because Brian Steele talked about his upbringing. We heard Rodalius Ryan's upbringing. We never got to hear about Quamarvious Nichols. So that was the first time we actually got insight into his upbringing. What happened to his mom, what happened to his dad. Like, we never got that until now. So everybody else, I know it was quite emotional. Nobody else accepted a plea. Quamarvious Nichols only. Some of us are on you and TLA stream. Shout out to the lead, of course. Thank you. He had me on, and some of y'all I know got introduced to me from him. So shout out to that. Appreciate y'all. But yeah, she just said adjourned, but she didn't say the time. I imagine they'll be back tomorrow, and it will be a lot of discussions, and the jurors probably won't be back till next week sometime. I imagine. I'm not a lawyer and I'm not in the courtroom. That's just my expectation. It's just my expectation. So I don't know how y'all feel. Let me ask this before I go and go make my TikTok for the people. Where's your video? Thank you. With me since last year. I love it. Here's the thing I will say. The mistrial motion where we ended, there was a mistrial motion on behalf of Quamarvious Nichols because he was one Quay, but there was also one on behalf of Marquavious Huey. So I imagine it's going to be declined. But yeah, that other one was from Huey, who was still a part of the trial, apparently. Hit that like button. Numbers matter. If you like this kind of content, this is the best coverage. Thank you. Appreciate y'all. Yes, please hit the like. If you're not subscribed, subscribe to my channel. We have a Patreon as well. We have a good time. We just like to have a good time. Hello, YouTube user. First of all, the name. I'm happy for him, but sad I won't see his handsome face again. Well, he's going to be on the road to finishing out his 4.5 years. He'll be on the road to getting started on the rest of hopefully his life, and what can be a better life, Wait, Meech be in here. Ponytail wasn't playing that at minutes a game. He was not playing. And that's the difference between some good lawyers. We have seen some plea deals where them factual acknowledgments are questionable. Harvey wasn't playing that. Harvey said, no, not so much. What else y'all saying in here? Yeah, it's giving no one else took a plea. It's as of now, for sure, no one else is taking a plea. I mean, I'd imagine there are no other ones. Maybe there's still some negotiations. No, I can't say for certain, but it's giving he was the plea. They probably were some negotiations, and maybe they all couldn't accept. They all couldn't agree on what that was going to be. We'll see. Hey, Teacher T, thank you. I love this coverage. I told my college students that I'm obsessed, and now some of them are following. I will be making, obviously, a recap, a shorter version, because I know this is longer and, you know, all of that. I'd be mindful that everybody don't want to rewatch hours. So I'll probably chop up the clip of him accepting the plea, him signing, what, you know, Harvey said, what Whitaker said. I'll chop that up a little bit later, just so we have it too. And then I also made a video of some mistrials from the day. So I'll be posting that today too. Yeah, Bruce Harvey's moment for sure was emotional for me. This is my mama, y'all. This is my mama. Thank you. I feel horrible for the victim's family. However, that is something they need to take up with the state. I agree. That would be really hard. You know what Whitaker said? She didn't really give. I wouldn't say that she was given too much, right? She said, I do find that from the evidence presented thus far that there is a basis at least, and there have been at least one, or maybe she said 2 overt acts that have been proven, but you can't really take too much from that. When will a new episode of Underreported drop? I haven't been doing Underreported. If you are new here or you've been looking at my YouTube, I had a podcast called Underreported where I covered a bunch of stories that I love that podcast, but I am not doing it anymore. Yeah, today was just that plea negotiation hearing. Or the plea deal hearing, rather, not even negotiation, because it's been negotiated. It was just the acceptance. It's for it to come in front of Whitaker, for her to hear both sides, her to accept this plea. Everybody signs, we move on. So that was today. There was nothing else. Yeah, I was wishing I was there today too. I wish I was running around. Yeah, that sounds about right. 31 months. That sounds, I said 2.5 years. That sounds about right, right? If he was in May 22, we're in 24. So that's already 24 months. Subtract May from, we're dang near November. So yeah, we're about there. Hey, shout out to you finding me through that though. As of now, that's it. I imagine there's no more, but again, you never know with this trial. You never know. Do you think will regret not taking the deal? I don't know who you're talking about specifically. I would imagine though, these attorneys, we've watched these attorneys are good. I would imagine that they have, if anybody straight up rejected the deal, I imagine that their attorneys have tried to inform them of all possibilities and reasons and why they should or should not. Like, I imagine they had many conversations about that. So I'm sure there's probably always buyer's regret, or I wonder if or maybe I should have, or what if I could have, or I'm sure there's those questions. But when you come to the decision to say no, I'd imagine that there has been thorough conversations back and forth, considerations, talks with family, I just believe based on the type of defense attorneys in this trial, I imagine that there's been a lot of conversations, and where you land is where you land. But again, I imagine, buyer's remorse. I buy stuff all the time and regret it. Yeah. All right. Overall, I think it was a good deal. That is my non-lawyer take. I'm sure there's a lot of creators who are covering and following this case now. So support them, support me. Like I said, like the video, subscribe, join my Patreon. I put all documents in there. I'm planning on talking about Rodalius Ryan's murder conviction on my podcast this week. I'm planning on talking about it. So it'll be out on Friday. You should look out for that because I'm going to kind of go through that. So that said, appreciate y'all. I'm going to go make my recap video for TikTok, for Instagram, and it'll be up here. All right. Have a good, what is today? Tuesday. See y'all. Like the video. Watch the podcast.